The facts in this case are really not so relevant for an Australian audience. In Australia, if the intention is to create many freehold units on one block of land, such as a block of flats or an apartment building, we use a system of strata title, where the land is owned in common and then each person owns their own part of the building. In the United Kingdom, the process had been to provide leases for long periods of time at nominal rent. A lease on your apartment for 99 years at 15 or 20 pounds per year was effectively the same as freehold title. In 1967, the British Parliament passed legislation intended to allow people with leases of this type to convert their leasehold to freehold upon payment of a fair price. We don't need to go into detail about the formula used to identify a fair price. However, Wentworth Securities combined with another company to exploit a loophole in the legislation, increasing the price if the leaseholder wanted freehold title. Lord Diplock clearly held the view that the loophole had arisen because the drafters of the legislation never imagined a party using these particular sneaky tactics. A purposive interpretation of the statute might require the court to add in words to close the loophole and therefore give effect to the statute's purpose. Lord Diplock said the words could be inferred into the statute in this way if three rules were met. First, if it was possible to determine precisely what the mischief was that it was the purpose of the Act to remedy. Secondly, if it was apparent that the draftsman and the Parliament had by inadvertence overlooked and so omitted to deal with an eventuality that required to be dealt with if the purpose of the Act was to be achieved. And thirdly, if it was possible to state with certainty what were the additional words that would have been inserted. In this case, while Lord Diplock clearly would have liked to have closed the loophole, he felt that he could not be certain what words the Parliament would have used, and so he was forced to allow the companies to exploit the loophole. From this case, we learn that in order to undertake a purposive interpretation of statute, the court sometimes can add words into the statute, but only with the greatest hesitation and the greatest care.